Well, from the foyer of the House of Commons tonight, I'm joined by three members of Parliament to discuss the latest developments in the SNC-Lavalin affair. Marco Mendicino is the Parliamentary Secretary to the Minister of Infrastructure and the former Parliamentary Secretary to the Minister of Justice. Michael Cooper is the Justice Critic for the official opposition and a member of the Commons Justice Committee. And Murray Rankin is the Justice Critic for the NDP and also a member of the Justice Committee. Good to see you all, gentlemen.
Happy to see you.
Mr. Mendicino, let me start with you. The Privy Council clerk admitted today that he and PMO officials met with Judy Wilson-Raybould to make sure that she understood the context and the consequences of a criminal prosecution of SNC-Lavalin, but that the pressure was not inappropriate. He said it was lawful. I guess at this point, how can we know that?
Well, first of all, let's go back to how we got to today. There was an allegation made by the opposition. The opposition asked for a committee hearing. They got the committee hearing that they wanted. They asked for witnesses to be called. I understand that a large number of the witnesses that they wanted to hear from are being heard from right now, including Mr. Wernick. And I would begin by pointing out that Mr. Wernick, who occupies the position of Clerk of the Privy Council, is a nonpartisan and the most senior official within the government. This is an individual who has served both Conservative and Liberal governments. And so I think that we have to place a tremendous amount of credibility and confidence in the testimony and weight in the testimony that he offered today. Okay, so that's where we're at right now.
All right, but by the time the Prime Minister meets with Jody Wilson-Raybould and with Michael Wernick, the Office of the Public Prosecutor has already decided SNC-Lavalin is not getting a plea deal. Right. Is the government's position that the meetings were just to make her aware of how damaging this will be to the company and its workers, or potentially could be, but with no suggestion that she should override that decision to proceed with the criminal prosecution?
Mr. Wernick made it clear that there were such meetings, and that those meetings were entirely appropriate and lawful, and that the purpose of those meetings, among other things, was to convey the potential consequences not to her, as she was then the Attorney General of Canada, but to the Canadians who would be impacted by the economic aspects of the overall outcomes in this particular case. So certainly when Mr. Wernick, who is the Clerk of the Privy Council, provides that evidence, and he does so in an unequivocal manner, I think it is an important part of the transparency and the explanations which our Canadians are entitled to expect. And it is through, most importantly, the vehicles which the opposition themselves asked for. So, you know, look, we're going to hear from Ms. Wilson-Raybould next week, and it will be open to her to provide her testimony. Okay, but I think with today's evidence, we have a higher degree of understanding of what was the context of those discussions and why they were lawful and appropriate.
Mr. Cooper, the clerk is a neutral public servant. It's his view that all those conversations, as Mr. Mendicino says, with Jody Wilson-Raybould were lawful and appropriate. What weight do you give his testimony today?
Well, I would agree with Marco on one thing. We do have a higher understanding, and the understanding that we have after today is that there's more evidence that the Prime Minister interfered inappropriately in the prosecution of SNC-Lavalin.
What evidence is that?
Well, I think it's important to go through the timeline. We know, as a result of Mr. Wernick's testimony, that on the September 17th meeting between former Attorney General Wilson-Raybould and the Prime Minister, that the former Attorney General unequivocally stated that she would not overturn the decision of the Director of Public Prosecutions not to enter into negotiations with respect to a DPA. What followed was a concerted campaign to encourage the minister to change her mind. We know, of course, about the December 5th meeting between Gerald Butts and Jody Wilson-Raybould about the SNC-Lavalin prosecution.
You say encourage her to change her mind. The other side is saying, well, to make her aware of all the consequences. Well, is there a, what's the nuance there?
Well, I'll tell you this. We have a December 19th meeting that we learned about where Mr. Wernick was meeting again with the Prime Minister and PMO officials. He then
he says to give her context. To
talk about economic considerations. Right. That the criminal code precludes that as a consideration in a DPA. Look, I think when you look at the chronology of events, this was not a one-off. This was a campaign. It was a number of meetings. And don't take my word for it. Jody Wilson-Raybould appears to believe that there was undue pressure. Apparently in Cabinet yesterday, she said she felt it.
Okay, I haven't had a chance to hear from her yet, but we'll get to that in a moment. Mr. Rankin, let me start by getting your view on the clerk's testimony today. Summarize it pretty simply, I think, as saying, yes, there was pressure to make sure she knew the significance of the decision, but it was lawful and appropriate. You okay with that?
No, I'm not. I mean, obviously, the facts have to speak for themselves. We have 2 resignations, Peter. We haven't talked about that. And when she decided to withdraw, when she was fired, or I'm sorry, removed as Attorney General, what did she do? Mrs. Wilson-Raybould decided to go public and say, the role of the Attorney General as an independent officer is sacred. And then again, when she left Cabinet, there was another such statement. Why? And then why is it that the Prime Minister's Chief of Staff has suddenly gone, and he resigned? And what did he say in his letter? He adverted to the whole Wilson-Raybould affair.
Right,
now,
but is it possible? Is it possible that what we have here is a dispute over, and I don't want to get too into the weeds. We've talked about it on this program before, but the Shawcross Doctrine.
Right.
Is there a difference between appropriate pressure, attempts to convince another colleague that these are the
Nothing wrong with that.
Nothing wrong with that.
Nothing wrong with that.
The problem gets into direction and to be told to make political considerations for a decision that you otherwise might not make. So
you can't direct her, but suddenly you removed her. I guess that's just fine.
Okay, so is that what you think happened here? Is that
That's what
she wouldn't
happened.
do what they wanted her to do, so she got arguably demoted in Cabinet?
Look at the timeline, Peter. I mean, the December 19th meeting, Wernick calls her up. She evidently doesn't cave, and then the Prime Minister fires her at the next opportunity as Attorney General. Coincidence? Okay. I think not.
Mr. Mendicino, let me have you respond to that.
What I would say to that is that obviously Mr. Wernick's evidence was consistent and clear and, quite frankly, compelling. The point of these discussions was to communicate to her in her capacity as the then minister that there were many considerations which hung in the balance as a result of SNC's operations in Canada. And we're talking about people's jobs. We're talking about people's lives. That is an entirely legitimate consideration for the government to be taking into consideration.
But so to Mr. Rankin's point and to Mr. Cooper's point, since then, not to create too big of a timeline here, the pressure is brought to bear, legitimate or not, and she'll have her own version of events. She stands by her decision that she's not going to override the Director of Public Prosecutions. She is moved,
a decision which remains intact.
She's moved out of the Attorney General's portfolio and replaced with another MP from Montreal. Some people would connect those dots and say, we can see what happened here.
You bet.
What do you say to that?
I say let the opposition continue to spin and engage in conjecture. I mean, that seems to be their modus operandi. And yes, I understand that it makes for political speculation, but at the end of the day, look, what I think Canadians will understand is that in the dynamics...
Well, I guess it makes for political speculation and says that unless and accept, and this is speculation, she gets a chance to say what's on her mind. And
and she will have that opportunity,
and if that's what she says, it's no longer political speculation. It's now the point of view of the former Attorney General in a Liberal cabinet.
Sorry, if I could just be permitted to finish, because I think Peter posed that question to me. What I would say is no one will speak on behalf of Ms. Wilson-Raybould. She will speak on behalf of both her and her interests, but as far as the reasons which underscore, her new assignment as the Minister of Veterans Affairs, as I have said on many occasions, a portfolio that is of the utmost importance to those individuals who are prepared to make the ultimate sacrifice, it is simply speculation. I think the broader takeaway for Canadians, though, from Mr. Wernick's testimony today is to shed some light on the dynamics of how big decisions are taken. Okay. No one minister operates in isolation, and particularly when we're talking about the kinds of decisions which impact jobs and Canadians' lives, naturally you would expect that ministers would consult with their colleagues so that we can take the best decisions possible.
Okay, Mr. Cooper.
No, I mean,
Mr. Cooper, jump in here, but I also want to, we had some conflicting testimony today. Mr. Lametti isn't guaranteeing that he'll find a way to, well, let me phrase this the right way. Yeah. Isn't guaranteeing that the solicitor-client concerns that Jody Wilson-Raybould has will be waived in time for her appearance next week at committee. And yet, Mr. Wernick said that he doesn't think any of these conversations are subject to solicitor-client privilege because she was the justice. She wasn't giving an advice. She was the decision-maker, so there's no solicitor-client privilege. So where does that leave us with whether she can talk or not at committee next week?
Well, I'd make 2 points. With respect to the testimony of David Lametti, he said it's all very, very complicated. He couldn't even indicate who could waive privilege? We know at the end of the day that can be made by the Prime Minister, and so it was really he was evasive. I think again part of this cover-up on the part of the PMO. As far as what Mr. Wernick said, that perhaps solicitor-client privilege doesn't really apply all that much. Well, it appears that Jody Wilson-Raybould seems to think that it does, at least based upon her comments in the House of Commons yesterday, when in a rather unprecedented fashion, she rose on a point of order and said that she wanted to speak her truth.
Okay,
it doesn't appear that she's going to be able to come to committee and speak her truth fully, and that's a problem.
Let me hear you on that, Mr. Rankin.
Let's go to the facts. She was removed by the Prime Minister from her job as Attorney General, and when she did so, she said, I have concerns about the independence of the Attorney General. And then on the weekend, the Prime Minister's Chief of Staff suddenly resigns and talks about this issue, talks about Madam Wilson-Raybould. Now, a lot of Canadians have a lot of questions. Nothing came up today that changed that. We have to ask her what she actually, when she gets to speak her story, as she asks to do. Hopefully the Prime Minister will unleash her and let her tell Canadians exactly why she appears to have felt that that line was crossed and inappropriate pressure was put upon her by political masters.
She'll be given that opportunity, as we've said before, but at the end of the day, what we have today, Peter, is a committee hearing.
Hang on, I'm sorry. She'll be given that opportunity. Like, so are you saying, do you think her testimony is only valuable if she's allowed to come and say exactly what happened, that she's not encumbered at all by the notion of solicitor-client privilege?
I'm not going to judge her testimony until I hear it, and I think that will occur.
No, but do you want her to be able to come and do you want her to be able to come and say exactly what she thinks happened to her in this whole process, and not to have to come and say, I can't answer that, I can't answer that, I can't answer that?
As I have said, I think we're all quite anxious to hear Ms. Wilson-Raybould's testimony, but the ambit of that testimony will be influenced by the advice that she's getting. It's not for me to speak on her behalf or anybody else, quite frankly, to speak on her behalf. But I do want to make some broad observations just before we close out. I would just say, look, they've got the committee they've wanted. They've got the witnesses they've wanted. They're not listening to the answers. And the real reason, Peter, is just, if I could just permit.
If I had a gavel, you'd hear it. Boom, boom. There.
Say they're not excited about the answers because they're not really interested in getting to the bottom of this.
I think we've all had sort of equal time to make our points here, and that's what we try to do, and I think everybody's had their say, but you know what? I'll bet next week we have a chance to talk again.
Okay. Thanks, Peter.
See you then.
Peter.
Thank you all. Bye now. Let's bring in our